Exciting episode here on the Professional Edge. We're talking about estate planning misses. My name's Sean Todd. I'm a tax attorney, CPA, and certified financial planner, and I appreciate your time in listening here on the Professional Edge. What we've talked about on session number 1 is disinheriting your kids inadvertently. That's number 1, or allowing them a stick of dynamite by giving them too much money at too early of an age. Then we digressed and we went over how to protect your assets going to your surviving spouse so you actually don't disinherit your kids. And if you're a listener and you have your estate plan and it says, "I love you, spouse, everything's going to you if you survive me, and then if you don't, remainder to our children." Well, that's a wake-up call. That is not going to guarantee that you're not going to disinherit your children, because then the surviving spouse may get remarried and it goes to that new spouse if they have that "I love you" will. So lo and behold, what we need to do is implement a testamentary trust for the benefit of those children and also for the benefit of that surviving spouse. So your assets go to a trust for the benefit of your surviving spouse, but when the surviving spouse passes away, you can guarantee that the assets inside that testamentary trust goes to the children of your first marriage. So if you want to make sure that you are not going to disinherit, or your surviving spouse is not going to disinherit your children, and yes, there is no intention to do that. It is always unintentional, but it does happen, and we have seen it time and time again. And once the cat's out of the bag, guess what? We can't put them back in there. So let's take a proactive approach. Give our office a call at 877-654-9798. That number again, 877-654-9798. Schedule that consultation, the advance of Zoom. We can do it from your location, or we can meet down here at Columbus in the Cunningham Center, or up in Atlanta if you want to see all the road construction around the Georgia perimeter. It's pretty amazing what they're doing, but it is a cluster, just saying. So let's continue on with this estate planning miss. How do we miss things on this estate plan? You say, hey, I got my last will and testament, I got my financial power of attorney, and I've got my advanced healthcare directive. I don't understand what he's saying about these estate planning misses. Well, if you don't put all the puzzle pieces together, you are not going to have a clear picture. So what puzzle piece is missing that we have not talked about? And that is the titles and also probate. How do titles matter? Well, if you have a piece of real estate and it is joint tenant right of survivorship, JTWROS in the legal field, real quick reference, then what it basically says, if dad and son bought some hunting land and dad said, you know what, for my son's 21st birthday, I'm going to update and do this JTWROS, and we're going to file this, and it's with my son. And lo and behold, we sort of go down the road a little bit longer, and then we build the family home on that piece of hunting property. And lo and behold, there is some friction in families, and son is just not getting along with mom. They just don't see eye to eye, and they just never really seen eye to eye. For some reason, there's just not good chemistry. Well, unfortunately, dad passes away. And wife pulls out the will, and it says, I give everything to my surviving spouse. And she thinks everything's come to her. Well, guess what? Nobody coordinated the titles on these assets. And again, being a tax attorney, we've done over 2,500 of these. We go through this to make sure it's a coordinated approach. We check the titles, we check the beneficiaries, and we check the estate planning document to draft it properly so it's a cohesive plan. So with that in mind, going back to our example, the wife pulls out the last will and testament, looks at her son, who they have this attenuated relationship, and says, you're not going to be hunting here no more. This is my property. I've never really liked you hunting on my land, and therefore take your hunting signs down. And the son says, wow, I remember dad saying something about, doing a deed, 21st birthday, whatever like that. So he goes to the courthouse, goes to the clerk of court, pulls that deed, and it says JTWROS, dad and son. Son gets a copy, and he goes back to mom, and he says, you know what? I think you need to move off and out of my house that's coming to me. And she goes, I'm going to my probate lawyer. My probate lawyer says, yep. Last will and testament says exactly what you think it says. It says you get everything. But unfortunately, the title on that hunting property, which now has the main dwelling, is going to the son, because the title on that deed supersedes anything inside that estate planning document. So lo and behold, son has the trump card, and if you play euchre, we know what the trump card is, or what is trump. It could be hearts, spades, diamonds, or clubs. I had to digress because I love playing euchre, being from the Midwest. So if you have not played euchre, look that up on how to play it. It is an incredible, fun game for a group of 4. So with that in mind, we're going back to this trump card. The son walks in and says, you can now vacate this premise. And this house is also an attachment to this. It is now considered real property. It's not an improvement. It's not mobile. So therefore, here's your eviction notice, and there is absolutely nothing that mom can do. The title on that deed superseded whatever was in the estate planning documents of dad. So that's why we need to coordinate the titles on assets. That is an estate planning miss, and yes, it does happen. Actual case that came across, the individual wife passed away early, and dad was pretty successful in having some rental property. Well, he had 2 sons, and they were helping in the rental property business, but dad, most men being men, got remarried. And the sons were very protective because they really didn't like that new stepmother, and they just sort of didn't trust her for some reason. The relationship was not that good. They thought she was a gold digger. Well, okay. So the sons actually kept the original last will and testament of dad and kept following him around because dad was in poor health. So lo and behold, fast forward, dad did pass away. And the sons were like, okay, we have the last will and testament of dad. And dad said that he's going to give X amount to that mother-in-law. And then the final balance is going to go to us. That's commercial real estate. And it was multiple millions of dollars. And they had the original last will and testament. So there was no shenanigans going on with her drafting a new will or taking them down. Nothing happened to that at all. So sons walk in, got the will probated. And the probate attorney starts working through these commercial properties and says, okay, sons, guess what? None of these commercial properties are going to go to you. And they say, wait a minute, the last will and testament's very clear. It says that that mother-in-law that we don't really get along with, don't trust, is only going to get X dollars. And then the commercial property portfolio is to go to my brother and I in equal shares. And he says, yes, that's exactly what that last will and testament says. But when we pull the titles on these commercial properties, it says that this is between your dad and your mother-in-law. Guess what? It is joint tenant right of survivorship. So lo and behold, the crafty individual, the mother-in-law that they didn't really trust, was probably correct. And this is an actual case that came down. And so the titles were all updated, joint tenant right of survivorship, and guess what? Had no effect on the will. The sons thought that the estate plan was airtight for them receiving that commercial portfolio of properties. And their mother-in-law is going to receive the only lump sum. Well, the smartest person in the room was that new wife, because she had the deeds to the properties redrafted to joint tenant right of survivorship. She just looked at the boys and said, yep, the estate plan is perfect the way it's drafted. Pretty smart cookie. So lo and behold, the sons actually contested this document, all these documents, all these joint tenant right of survivor deeds to the commercial real estate portfolio that was north of $5 million worth of contest here, because sons, if those quitclaim deeds that changed it from dad's name to joint tenant right of survivorship were actually valid, then they would be disinherited of $5 million plus of commercial property. So they petitioned the probate court to say, ooh, these need to be set aside. There was something going on mischievous here. Well, lo and behold, the probate court actually ruled in favor of the second wife, the name on the joint tenant right of survivorship deed. Said, lo and behold, dad had to be of clear mind and conscience to sign these deeds one after another, and therefore that deed is going to supersede what is in the estate planning document. Gavel hammers, lo and behold, she got all the commercial property. So this is an estate planning oversight or an estate planning miss, that we're not looking at the titles to properties. So if that right there gives you a little bit of hair standing up on the back of your neck that you don't understand what's going on, give our office a call at 877-654-9798. That number again, 877-654-9798. Meet at the Cunningham Center up here in Atlanta or via Zoom. But these are the things that listeners here on the Professional Edge don't need to miss. We need to get these coordinated to make sure that the estate plan is cohesive. And there's not some ill actions. Again, the smartest person in the room was the lady that got the quitclaim deed updated to a joint tenant right of survivorship, because the title supersedes whatever is in the estate planning document. So, yes, the son's mistrust of that new spouse was very warranted. And come to find out, she was the smartest person in the room, and they were disinherited. So if that right there is of concern, or nobody's looked at the titles, or you got some estate planning documents done, and no one asks you for a copy of your deed, that's a red flag. That's I'm not sure your estate plan is comprehensive. So take a look at that. We've discussed a lot. We talked about leaving things on the estate planning miss to your kids, not leaving it in trust for your kids to protect it from the potential claims of that ex-spouse. We've talked about leaving things to a testamentary trust for your surviving spouse so you don't disinherit your kids. So a great place to get started on your estate plan, go to emcadvisors.com. That is Echo Mary Charlie Advisors.com. And on there, you can request your ultimate estate plan guide. And I appreciate you listening here on the Professional Edge. I hope you have garnered some information so you, as a listener here on the Professional Edge, don't have these estate planning misses. My name's Sean Todd, tax attorney, CPA, and certified financial planner. Thanks for listening to the Professional Edge.
We've all thought about it. Everyone listening will need one. Not having one can cause untold heartache, family conflict escalating to the point of a lawsuit. One simple thing that avoids all that: an effective estate plan. As a practicing tax attorney, Sean Todd with Estate Management Counselors has completed over 1,000 estate plans during his 15 years of professional practice. He can help you implement an effective estate plan, coordinate your financial accounts, and make sure you have named the proper beneficiaries to maximize your tax savings. Call 877-654-9798 today and let tax attorney Sean Todd help you implement an effective estate plan. Call 877-654-9798 today. As a tax attorney, CPA for over 15 years, Sean Todd has implemented over 1,000 individual estate plans. He has recently authored an especially helpful guide, How to Unlock the Ultimate Estate Plan. This guide has helped many individuals to understand the benefits of an estate plan and how to avoid unintended disasters. Sean has made every attempt to write this in plain English. To receive this valuable guide, How to Unlock the Ultimate Estate Plan, call 1-877-654-9798 $9.98 and request your complimentary copy today, or by emailing your request to info@emcadvisors.net.